Question 1. In Texas, if an insurer needs additional time to evaluate a claim after receiving all requested information, it must notify the claimant and may delay payment for up to how many days? A. 15 calendar days. B. 30 calendar days. C. 45 calendar days. D. 60 calendar days. Answer: C. 45 calendar days. The correct timeframe is 45 calendar days. While Texas law requires an insurer to accept or reject a claim within 15 business days of receiving all necessary information, it allows for an extension of up to 45 calendar days if the insurer has a reasonable basis for needing more time and notifies the claimant. This rule balances the need for a prompt decision with the reality that some claims require a more in-depth investigation. Think of the 15-day rule as the standard, but the 45-day extension as a built-in safety valve for complex situations. Question 2. An insured's home is damaged by a fire. The insured and the insurance company agree on the scope of the damage but disagree on the financial value of the loss. Which policy condition is specifically designed to resolve this type of dispute? A. Subrogation. B. Appraisal. C. Arbitration. D. Abandonment. Answer: B. Appraisal. The appraisal clause is the correct mechanism for resolving disputes over the amount of a loss when coverage itself is not in question. Under this condition, both the insured and insurer hire their own appraisers, and those two appraisers select a neutral umpire. An agreement by any two of the three is binding. This process is used to determine the financial value of the damage, such as the cost to repair a roof, not whether the roof damage is a covered peril. Remember, appraisal is for how much, while legal action or arbitration might address disputes over if the loss is covered at all. Question 3. Under a standard Texas personal auto policy, which of the following is a primary function of personal injury protection, PIP, coverage? A. To pay for damages to the other driver's vehicle if you are at fault. B. To pay for medical expenses and lost wages for the insured and their passengers, regardless of fault. C. To protect the insured against claims from drivers who have no insurance. D. To cover the cost of a rental car while the insured's vehicle is being repaired. Answer: B. To pay for medical expenses and lost wages for the insured and their passengers, regardless of fault. Personal injury protection, PIP, provides first-party benefits for the insured's own medical bills, funeral costs, and 80% of lost income without needing to establish who was at fault in an accident. This no-fault characteristic is the key feature of PIP, as it is designed to provide quick payment for economic losses suffered by the insured, their family members, and any passengers in their vehicle. Unlike liability coverage which pays others, or uninsured motorist coverage which protects from uninsured drivers, PIP directly addresses the immediate financial needs of the insured. Question 4. An adjuster's actions or statements that lead an insured to believe a certain right under the policy has been given up may result in the insurer being legally barred from denying a claim. This is an example of which legal doctrine? A. Adhesion. B. Subrogation. C. Estoppel. D. Indemnity. Answer: C. Estoppel. Estoppel prevents an entity from asserting a right that they have, by their previous actions or statements, led another party to believe they would not enforce. If an adjuster consistently implies a claim is covered and the insured relies on this assurance to their detriment, for example, by authorizing expensive repairs, the insurance company may be estopped from later denying the claim based on a policy exclusion. It essentially means the insurer is held to the position it appeared to take. A simple way to remember is that estoppel stops an insurer from going back on their implied word. Question 5. In a surety bond, which party is the one who agrees to be financially responsible for the failure of another party to perform an obligation? A. The principal. B. The obligee. C. The surety. D. The grantor. Answer: C. The surety. The surety is the party, often an insurance company, that guarantees to the obligee that the principal will fulfill their obligation. A surety bond involves three parties: the principal, who has the duty to perform, the obligee, to whom the duty is owed, and the surety, who guarantees the principal's performance. For example, in a construction project, the contractor is the principal, the property owner is the obligee, and the insurance company providing the bond is the surety, promising to pay the owner if the contractor fails to complete the job. Question 6. Which of the following actions by a claims adjuster would most likely be considered an unfair claims settlement practice under Texas law? A. Paying an undisputed portion of a claim promptly while continuing to investigate a disputed portion. B. Misrepresenting a pertinent policy provision relating to a coverage at issue. C. Requesting a formal proof of loss statement from the insured to document the claim. D. Denying a claim for a loss that is clearly excluded under the policy terms. Answer: B. Misrepresenting a pertinent policy provision relating to a coverage at issue. Misrepresenting a policy provision is a clear violation of the Texas Unfair Claims Settlement Practices Act. This law sets standards for how insurers must behave and expressly prohibits misleading a claimant about what their policy actually covers in order to discourage a claim or reduce a settlement amount. For example, telling an insured their policy doesn't cover water damage from a burst pipe when it actually does is a prohibited act of misrepresentation. A core principle of good faith handling is to be honest and transparent about the coverage provided by the insurance contract. Question 7. All of the following information is typically found on the declarations page of an insurance policy except A. The policy period and premium amount. B. The name and address of the named insured. C. A list of policy exclusions. D. The limits of liability for coverages. Answer: C. A list of policy exclusions. A list of policy exclusions is not found on the declarations page, it is located in a separate section of the policy form. The declarations page acts as the personalized cover sheet for the policy, containing specific information unique to that insured, such as who is insured, what property is covered, the policy's effective dates, the coverage limits, and the premium. Exclusions, on the other hand, are general conditions that apply to all policyholders with that form and are detailed within the main body of the policy contract. Question 8. In Texas, after an insurer receives a claim, it must acknowledge the claim, begin an investigation, and request all necessary information from the claimant within what time frame? A. 10 calendar days. B. 15 business days. C. 15 calendar days. D. 30 business days. Answer: B. 15 business days. Texas law mandates that an insurer must respond within 15 business days of receiving notice of a claim. This initial response must include acknowledging the claim, starting an investigation, and asking the claimant for any statements, forms, or items needed to evaluate the loss. The use of business days is a critical detail, as it excludes weekends and holidays, giving the insurer a slightly longer period than 15 calendar days. This rule ensures that claimants receive prompt and professional communication right from the start of the claims process. Question 9. An insured's driver's license was suspended, and they failed to notify their auto insurer. This failure to inform the insurer of a significant change in risk is an example of A. Misrepresentation. B. Breach of warranty. C. Concealment. D. Estoppel. Answer: C. Concealment. Concealment is the failure to disclose a known, material fact when there is a legal duty to do so. In this scenario, the suspension of a driver's license is a material fact because it directly impacts the level of risk the insurer is covering, and the insured had a duty to report it. Unlike misrepresentation, which involves making an untrue statement, concealment is about withholding information. Keeping this key detail secret prevents the insurer from accurately assessing the risk it has assumed. Question 10. A lightning strike hits a tree in an insured's yard, causing the tree to fall onto their house and damage the roof. The lightning strike is considered the A. Proximate cause. B. Concurrent causation. C. Direct loss. D. Intervening cause. Answer: A. Proximate cause. The proximate cause is the primary event in an unbroken chain of events that leads to a loss. In this case, the lightning strike initiated the sequence of events, directly causing the tree to fall, which in turn damaged the house. Even though the falling tree was the final object to cause damage, the entire loss is attributed to the lightning because it was the starting point without which the damage would not have occurred. For a loss to be covered, the proximate cause must be a covered peril. Question 11. An adjuster is sent to investigate a fire claim at a warehouse. To protect evidence and prevent further damage, the adjuster should consider the property that was not destroyed by the fire to be A. A total loss. B. Debris. C. Salvage. D. An indirect loss. Answer: C. Salvage. Salvage refers to damaged property that is taken over by the insurance company after paying for a loss, usually a total loss, to reduce the overall cost of the claim by reselling it. Even in a partial loss, an adjuster must consider the potential salvage value of items that can be recovered, repaired, or sold. For instance, if a warehouse fire destroys half the inventory, the undamaged or lightly smoke-damaged goods have salvage value that must be accounted for when settling the claim. The key concept is that the insurer has a right to the salvage to mitigate its payout. Question 12. Under a standard homeowners policy, personal property coverage, coverage C, often includes special limits of liability for certain types of valuable items. Which of the following items is typically subject to a special limit? A. Clothing. B. Furniture. C. Firearms. D. Kitchen appliances. Answer: C. Firearms. Firearms are typically subject to a special limit of liability for theft under personal property coverage. Homeowners policies place sublimits on items that are highly susceptible to theft or have unique value, such as money, jewelry, silverware, and firearms, to manage the insurer's exposure to risk. For example, while an insured might have $100,000 in total personal property coverage, the policy might only pay up to $2,500 for the theft of firearms. To get full coverage for these items, the insured would need to purchase a separate policy or add a specific endorsement. Question 13. An adjuster has concluded an investigation and determined that a claim should be denied based on a policy exclusion. What is the adjuster's most important responsibility at this point? A. To close the file immediately to meet deadlines. B. To offer a small nuisance payment to avoid a lawsuit. C. To provide the claimant with a prompt, clear, and written explanation for the denial, referencing the specific policy language. D. To discuss the denial only with the insured's agent. Answer: C. To provide the claimant with a prompt, clear, and written explanation for the denial, referencing the specific policy language. Providing a prompt and clear written denial that cites the specific policy language is a critical duty and a requirement under the Texas Unfair Claims Settlement Practices Act. A proper denial letter must explain the reason for the decision and point to the exact words in the policy, like an exclusion, that support the insurer's position. This ensures transparency, helps the claimant understand the outcome, and creates a clear record of communication, which is essential for good faith claims handling. Simply closing the file or only talking to the agent would be improper and could lead to complaints or legal action. Question 14. Which part of an insurance policy contains the insurer's fundamental promise to pay for covered losses and describes the scope of coverage? A. The declarations. B. The insuring agreement. C. The conditions. D. The exclusions. Answer: B. The insuring agreement. The insuring agreement is the heart of the policy, as it contains the core promise from the insurance company to the insured. This section outlines what the insurer agrees to do in return for the premium, specifying the perils covered, the types of losses paid, and the overall scope of protection. While the declarations page personalizes the policy and the conditions and exclusions sections set rules and limits, the insuring agreement is what establishes the fundamental obligation to pay. Think of it as the "we promise to pay for" section of the contract. Question 15. The Texas rule for comparative negligence states that a claimant's recovery is barred if their percentage of fault is A. Greater than the other party's fault. B. 50% or more. C. 51% or more. D. Any percentage, as Texas is a contributory negligence state. Answer: C. 51% or more. Texas follows a modified comparative negligence rule, often called the 51% bar rule. Under this doctrine, a claimant can recover damages as long as their share of the fault is 50% or less. However, if the claimant is found to be 51% or more responsible for the accident, they are barred from recovering any damages at all. For example, if a claimant has $10,000 in damages but is found 20% at fault, their award is reduced by 20% to $8,000. But if they were found 51% at fault, they would receive nothing. Question 16. What is the primary purpose of a deductible in an insurance policy? A. To fund the insurance company's administrative costs. B. To reduce the number of small claims and help lower premiums. C. To punish the insured for being negligent. D. To establish the maximum limit of liability. Answer: B. To reduce the number of small claims and help lower premiums. A deductible's main purpose is to eliminate small, frequent claims and encourage risk prevention by requiring the insured to bear the first portion of a loss. By not having to process and pay for every minor incident, insurance companies save on administrative costs, which allows them to offer lower premiums to all policyholders. For example, with a $1,000 deductible, an insured would not file a claim for a $700 loss because it's below the deductible amount, making the insured responsible for minor repairs. This cost-sharing mechanism makes insurance more affordable and focused on significant financial losses. Question 17. The legal principle that requires an insured to be restored to the same financial position they were in just before a loss is known as A. Subrogation. B. Adhesion. C. Utmost good faith. D. Indemnity. Answer: D. Indemnity. The principle of indemnity is the foundation of insurance, stating that a policy should not allow an insured to profit from a loss but should instead make them whole again. This means the insurance payment should cover the amount lost, returning the insured to their approximate financial condition prior to the event. For instance, if a 10-year-old car is totaled, indemnity means the insurer pays the car's current market value, not the cost of a brand new car, because paying for a new car would put the insured in a better financial position than before the loss. Question 18. An adjuster is handling a liability claim where the at-fault party's policy includes supplementary payments. Which of the following costs would typically be covered under these payments? A. The primary liability judgment up to the policy limit. B. The cost of repairing the insured's own vehicle. C. The premium for a bail bond required of the insured. D. The insured's lost wages for attending court. Answer: C. The premium for a bail bond required of the insured. Supplementary payments provide coverage for specific expenses related to the defense of a claim, and these payments are made in addition to the policy's liability limits. Common supplementary payments include the cost of defense, premiums for certain bonds, like bail bonds up to a specified amount, and interest that accrues on a judgment. They are designed to cover the insured's direct litigation-related expenses, distinguishing them from the primary liability coverage that pays for damages owed to the third party. Question 19. A signed, sworn document provided by the insured to the insurer that details the date and cause of loss, the value of the property, and any other insurance on the property is called a binder. B. Proof of loss. C. Non-waiver agreement. D. Certificate of insurance. Answer: B. Proof of loss. A proof of loss is a formal statement made by the insured that is required by the insurer before it is obligated to pay a claim. This document serves as the insured's official declaration about the facts and figures of the loss, providing detailed information that the insurer needs to complete its evaluation and settlement. By signing it under oath, the insured affirms the truthfulness of the information, which is a key step in finalizing the claim process. Think of it as the insured's official, itemized bill to the insurance company for the damages sustained. Question 20. In Texas, a licensed claims adjuster's license is valid for a period of A. 1 year. B. 2 years. C. 3 years. D. 4 years. Answer: B. 2 years. A Texas adjuster license is issued for a 2-year term, expiring on the licensee's birthday. To maintain the license, the adjuster must complete continuing education requirements and submit a renewal application before the expiration date. This 2-year cycle ensures that adjusters stay current with industry practices, laws, and regulations through ongoing education. Always remember to check your license expiration date to ensure you remain compliant and eligible to work. Question 21. Which dwelling policy form provides coverage for losses on an open perils, all-risk, basis for the dwelling and other structures? A. DP1, basic form. B. DP2, broad form. C. DP3, special form. D. HO4, contents broad form. Answer: C. DP3, special form. The DP3, or special form, provides the highest level of property protection among the dwelling policies by covering the dwelling, coverage A, and other structures, coverage B, against all risks of direct physical loss, except for those specifically excluded. This is known as open perils or all-risk coverage. In contrast, the DP1 and DP2 provide named perils coverage, meaning they only cover losses from the specific perils listed in the policy. The DP3 is the go-to choice for property owners who want the most comprehensive protection available under a dwelling policy. Question 22. After paying a claim for damages caused by a negligent third party, the insurer may attempt to recover the amount paid from that third party. This process is called A. Salvage. B. Arbitration. C. Subrogation. D. Contribution. Answer: C. Subrogation. Subrogation is the legal right of an insurance company to pursue a third party that caused a loss to the insured. After the insurer pays its own insured for the damages, it steps into the shoes of the insured to seek reimbursement from the at-fault party. For example, if another driver runs a red light and hits your car, your insurer might pay for your repairs and then subrogate against the at-fault driver's insurance company to get that money back. This process holds the responsible party accountable and helps control insurance costs. Question 23. Intentionally deceiving an insurer to receive benefits to which one is not entitled is the definition of A. A hazard. B. A tort. C. Negligence. D. Fraud. Answer: D. Fraud. Insurance fraud involves any act of deliberate deception committed against an insurer for the purpose of unlawful financial gain. This can range from staging an accident to exaggerating the value of stolen items on a claim form. The key element is intent. Fraud is not an accident or a simple mistake, but a calculated effort to cheat the system. As an adjuster, being able to recognize the potential red flags of fraudulent activity is a critical part of the job. Question 24. A business owner purchases a policy to protect against claims of bodily injury or property damage caused to customers or the public on the business premises. This type of policy is known as A. Commercial property insurance. B. Workers' compensation insurance. C. Commercial general liability, CGL, insurance. D. Business owner's policy, BOP, property section. Answer: C. Commercial general liability, CGL, insurance. Commercial general liability, CGL, insurance is specifically designed to protect a business from third-party claims of bodily injury, property damage, and personal and advertising injury. For example, if a customer slips and falls in a store, the CGL policy would respond to cover the customer's medical expenses and any resulting lawsuit. While a business owner's policy, BOP, often includes CGL, the core coverage for this specific risk is the CGL itself, which is essential for nearly every business that interacts with the public. Question 25. Under the Texas Workers' Compensation System, what is the maximum duration for which an injured employee can receive medical benefits for a covered injury? A. 2 years from the date of injury. B. 401 weeks. C. For as long as is reasonable and medically necessary. D. Until maximum medical improvement is reached. Answer: C. For as long as is reasonable and medically necessary. Texas law provides lifetime medical benefits for injuries covered under workers' compensation, as long as the care is reasonable and medically necessary to treat the work-related injury or illness. Unlike income benefits, which are subject to time limits, like 401 weeks for impairment income benefits, medical benefits have no arbitrary time or dollar cap. This ensures that an employee who suffers a serious, long-term injury can continue to receive the treatment they need for the rest of their life. This is a crucial distinction to remember between the different types of workers' compensation benefits.